This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about the fact that the covenant of good faith, implied in every contract of insurance, is an ethical doctrine. And as part of those ethical doctrines is the ethics and the reservation of rights, as applied in an insurance claim. An insurer that reserves its rights under a policy of insurance will usually raise a request by the insured for independent counsel. However, unless the reservation actually raises the need for the application of the ethical duty of an attorney to avoid representing conflicting interests, there is no obligation on the part of an insurer to retain independent counsel. If that duty exists, independent counsel is required. If there is no conflict, the insurer may assert its right to control the defense of the insured with counsel of its choice. In Federal Insurance Company versus MBL Inc., the California Court of Appeal dealt with a case where, after soil and groundwater contamination in the City of Modesto was traced back to a dry cleaning facility known as Halford's Cleaners, the federal government brought a comprehensive environmental response compensation and liability act, CERCLA, action against the owners of the property on which Halford's was located, as well as the lessees who owned and operated the facility, to recover the costs of monitoring and remediating the contamination. The defendants in the Lyon action subsequently filed third-party actions against, among others, appellant MBL Inc., a supplier of dry cleaning products, including perchloroethylene, or PCE, seeking indemnity contribution and declaratory relief. MBL tendered the defense of these third-party actions to its insurers, Federal Insurance Company, Centennial Insurance Company, Atlantic Mutual Insurance Company, and Nationwide Insurance Company, and Utica Mutual Insurance Company, and the Great American Insurance Company. Hereafter I'll refer to them as the insurers. The insurers accepted the tender of defense, subject to reservations of various rights, and retained counsel to provide MBL with a defense. MBL refused to accept retained counsel, arguing the insurer's reservation of rights created a conflict of interest, and demanding the insurers instead pay for counsel of MBL's choosing. The insurers denied there was any such conflict of interest and filed declaratory relief actions. The trial court granted summary judgment in favor of the insurers, finding there was no actual conflict of interest. In a related appeal, Great American sought to preserve its rights to equitable contribution from the other insurers in the event MBL's appeal was successful. Alone among the insurers, Great American paid MBL's independent counsel for the cost of defending the third-party actions, subject to a reservation of the right to reimbursement from MBL if it succeeded in its declaratory relief action. MBL supplied PCE and other dry cleaning products to dry cleaning facilities and has done so for a number of years. In 2007, MBL was named as a defendant in a number of third-party complaints and cross-complaints filed in the Lyon action. According to the allegations of the Lyon action, wastewater containing PCE was discharged into the sewer system as part of Halford's dry cleaning operations until the mid-1980s. PCE was also leaking from an old dry cleaning machine through the floor of the facility into the soil and groundwater. In 1989, the site was placed on the National Priorities list of hazardous waste sites. MBL retained defense counsel who tendered the defense of the Lyon action to the insurers, requesting they appoint them as cumas, or independent counsel. The insurers accepted the tender of defense subject to various reservations of rights and appointed counsel to defend MBL. MBL refused to allow the insurers' appointed counsel to associate as defense counsel, asserting it was entitled to independent counsel of its own choosing pursuant to Civil Code Section 2860 of the state of California. The insurers advised MBL it was only entitled to cumas counsel or independent counsel if their reservation of rights created a conflict of interest, and with the exception of Great American, refused to pay the defense costs incurred by MBL's counsel. The insurers moved for summary adjudication of the causes of action for declaratory relief regarding their duty to provide independent counsel to represent MBL, and the insurers argued that the limited reservation of rights asserted by these insurers did not create a conflict of interest under California Civil Code Section 2860, which modified the original Cumas Society decision. In June of 2009, after the matter was briefed and argued, the trial court granted the insurer's motion. In its order, the court noted that the specific reservation of rights by the insurers did not present a conflict which would require the appointment of independent counsel. The court further found that the general reservation of rights to deny coverage does not present a conflict which would require the appointment of independent counsel, and after amending its complaint to add a cause of action for reimbursement against MBL, Great American filed a motion for summary adjudication and summary judgment against MBL, and that motion further sought summary judgment on MBL's cross-complaint against Great American. The trial court granted Great American's motion in its entirety and entered a declaratory and money judgment in favor of Great American and against MBL. So the lesson is an ethical insurer can sue an insured for declaratory relief and for return of money spent in defense when it believed it did not owe that defense. This video and blog was adapted from my book, The Compact Book on Ethics for the Insurance Professional, that is available from Amazon.com on the links provided in the blog posting. This video is available, and this blog is available to anyone who clicks on the URL zelma.com/blog. It's free. And if you subscribe, you will be provided with notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 4,850 blog posts. You can also subscribe to the videos on rumble.com and youtube.com. And if you do, I'd appreciate it if you click on the thumbs up button on Rumble and the like button on YouTube. And if you're interested in more detail information about insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.